ultimate paragraph is the entire reproduction of the report itself, together with its findings and recommendations and everything. And then it's got whatever paragraph it will be as a concluding paragraph. And she signs it on the 26th of June, 2026. So officially, for purposes of investigation, that is the first time IDEC even becomes aware of the basis on which General Masemola eventually had to terminate on the 15th of May, 2025. You would accept that. Logic would tell me. Unless, once again, you or somebody within IDEC were able to explain that they obtained that audit report prior to the complainant, General Matlou, submitting it in the form of an affidavit on the 26th of June, 2026. Now, to the extent that your investigators told you there was a preliminary report, which of course I take issue with, did they indicate when they received that final audit report prior to the 26th of June, 26, if they ever did?
No, I just know that there was a preliminary report with the Section 27.
Then
I don't have the details, Chair, unfortunately.
We will await that affidavit and see. Now, this is, again, I'm still staying with General Matlou's affidavit, and it's because these are now significant and important institutions in the country. This is IDEC, SAPS. When this affidavit is received in the terms that it is, it does not at least implicate General Masemola on the face of it, does it? The affidavit at 3519.
Oh, you're talking about the Section 27, sorry.
Yes, the Section 27 yes. From General Matlou.
No.
It doesn't implicate General Masemola.
Sorry.
The only reference I see to General Masemola is at paragraph 8,
yes,
wherein she states that she advised him to terminate, to consider terminating, which he eventually did on the 15th of May.
Correct, but she does go on to say, in her way, that having advised the National Commissioner to terminate the contract with Medicare to save the SAPS from irreparable harm and to diminish the financial prejudice being suffered by the SAPS, General Masemola ultimately terminated the contract with Medicare on or about the 15th of May. By that time, SAPS had suffered prejudice of approximately 50 million.
And that prejudice of 50 million being what SAPS was obligated to pay in terms of the contract. That's what you call prejudice.
At that time, when she told him about the termination, she indicated this contract is unlawful and should be stopped. So I don't know how the payments then become legitimated. So I understand that the system, in terms of the system, there is a contract. Till it is stopped, payments will continue. I understand this to read.
Advocate Johnson, apologies.
Sorry.
You and I know she has no power to invalidate a contract which on the face of it is valid. So when she says stop that contract, in what capacity? She's not a court.
She's not a court, no.
Yes.
But she is the risk. She's the head of risk and integrity, and she is saying to him that this contract has been unlawfully awarded, and we need to stop the contract. That this contract has been unlawfully awarded, and we need to stop the contract. She says because of the time that has passed, the payments went out.
Sorry, this affidavit doesn't say when she told him to stop. So on this affidavit, at least we who are reading it now, and maybe you had other information that is not in the affidavit. On this affidavit, we don't know whether she told him in January, whether she told him on the 14th of May, and what the expenditure was by the time she told him when it dawned on her that this contract should be terminated. So it's not what you're telling us now is not in the affidavit. So maybe tell us, where did you get it from that she told him to terminate, he did not, and in the intervening period after that, and the 15th of May, 50 million rand was spent, which would not have been spent had he acted when she told him. There's facts that are not contained in this affidavit, and they hold only if you got them in another way.
I understand. It's how I read the affidavit, that there is, in paragraph 2, there's an unlawful awarding of a tender to Medicare for a period of 3 years to the value of 360 million. She sets out that she suspects that the process is flunked.
Allow me to stop you. You have accepted in your discussion with Ms. Sillo that the only mention of General Masemola is paragraph 8. That's the first time she says anything about him. That doesn't mean that she has not investigated and this is what she has found. She has done that. That's why she gives you the background story in this affidavit. And then at paragraph 38, she says something that now directs to General Masemola. And in fact, on a reading of this paragraph, the way she says it, she may not have intended to, but the way she says it is, I advised him to terminate, and he did terminate. That's what paragraph 8 tells you. You say, well, she told him earlier, he took his own time to terminate when she had told him earlier. And all I'm putting to you is that which you are saying doesn't arise from this affidavit. On a sensible reading of this affidavit, in paragraph 8 in particular, or any paragraph in the affidavit, those facts that you are now speaking to are not here. Where did you get them from?
Commissioner Baloyi, I read paragraph 8 as her having advised him to terminate the contract. General Masemola ultimately terminated the contract. That he does. I read it from that ultimately. There wasn't an immediate action. It was ultimately terminated and then prejudice was suffered. I don't take it from anywhere else, but just that reading.
But you see, to criticize him for not terminating immediately, you must know when was he informed. Logic dictates that.
It doesn't come out of here.
Yes, and that's a simple point I'm making, that on this paragraph and the whole affidavit, we don't know when she told him, right? So if we don't know when she told him, we are not in a position, and that you must accept, we are not in a position to say he delayed actioning her advice because she doesn't tell us when she informed him. We are not in a position to say because of his delay after she advised him, SAPS incurred 50 million rand expenditure, which it would not have incurred. It's not there aren't facts in this affidavit that make us able to conclude that therefore he delayed and is liable, he failed to secure the monies or the assets of SAPS. You accept that?
I accept that.
All right, thank you.
Thank you, Commissioner. And I take it that it is General Matlow's affidavit that triggered the IDEC investigative powers and eventual prosecution of however many accused there are. Am I correct?
Correct.
You recall we started this conversation having considered what you stated, what you discussed with members of ad hoc. And there I referenced page 586 where Mr. Ngola told you that there was an allegation that IDEC is actively participating in a well-coordinated attack against General Mkhwanazi, General Masemola, and General Khumalo. Are you aware of it? You said you've heard of that allegation, but there's no truth to it. After this entire exercise we've gone through, do you still maintain that there is no truth or there is no basis to even believe such a narrative or an allegation?
Chair, I maintain that there was no sorry, I don't have my file for the...
No, ask me.
Repeat the words.
The engagement at ad hoc?
Yes.
It's file 3, page 586.
Sorry, file 3. Sorry, Chair.
It's quite in order. Page 586.
586.
Midway the page. This is after, I guess you'd be faster to find your own name, after you say that is correct. Then Mr. Ngola puts the question, there is an allegation. And then that's immediately followed by your response, and then you reference other criminal matters within the IDEC space. And you conclude, while we're at it, with the words, there is also no witch hunt against Lieutenant General Khumalo because there were no matters brought to IDEC prior to the referral by Mr. Adams. That's the part I'm reading. And I can very well perhaps appreciate the position you were in at the time you responded. Mine is slightly different. Do you still maintain the position after our 1.5 days of engaging with specifically decisions by IDEC targeting, aimed at least 2 of these generals and the PKTT? Can you still say the narrative is baseless?
Chair, the response I have is, at no stage did any of these cases start on the basis of wanting to target any individual, even those that I mentioned. We dealt with the investigations. In the course of these 2 days of engagements, and in the manner in which we have engaged, we would have to accept that we could have done things differently and or could have done things better. But that does not in itself make it a witch hunt or a target. They were not targeted at all. I accept that process is criticized. The manner in which things were done were criticized. I accept that criticism, Chair. And what I'm saying is that shortcoming does not make a targeting. It does not make it a witch hunt. It does not of itself say, we did it this way just to get to them. In the manner that these matters were presented, it is clear, and from the lengthy debates that poor Chair has had to have with me in getting us to understand our logic versus that logic, it is clear that we worked on what we had, interpreted the law as we have. There is a difference of opinion, and that difference of opinion, Council, highlights that things look the way they do and should have been done differently.
We dealt with one of the many Section 28 summonses.
Are you leaving this page?
No, I'm coming back to it.
Okay, thank you.
And at 3361 file 9, and we dealt with that quite extensively yesterday. I'm at 3363. Where, following Mr. Adams's complaint, in whatever terms it was expressed, you signed off on a summons that asked for a litany of documents that had no bearing on the complaint, including a list of all provincial heads and section heads who were stationed in Division Crime Intelligence, the performance assessment of all major generals for that year, the advertisement for that position, audio recordings and interviews. Then you want documentary records that General Jacobs refused to return. We have established that all those factors bear no relevance to the complaint, and I think we settled that yesterday.
We have.
We have. Then you ask, in the same summons, for documentary files and applications for promotions and commanders and members of the political task teams through deviation. According to you, the PKTT did not feature anywhere. So once again, that is way beyond the scope of the original complaint by Mr. Adams. You recall?
I recall.
We then went to page 3531, which is annexure, you don't have to go there, annexure 397. That is the Section 28 summons signed by Advocate Manilao, which wanted the identities and certified travel documents of PKTT members who went to arrest Mr. Adams. And he does so under the cast number relating to the Mukwele appointment. You could not explain that Section 28, and I think we landed at a place where you said it ought not to have happened. Correct?
Correct.
In light of at least the three that I have named, logic dictates that it was a concerted effort to either discredit or somehow prejudice them. How can you sit there and you say the narrative is entirely wrong? And how do you suggest that it's just a difference of opinion? It's not. The facts, at least, are on the side of the narrative. What facts do you put forth to countenance that?
If you grant me an opportunity
Absolutely.
just to answer on why, because I had to ask the question, because I wasn't aware of this, Commissioner Baloyi. I did ask Advocate Manilal why this Section 28 went out, and I give you the explanation as follows. Part of the bail conditions in that matter was that the accused, which at the time would have included Lieutenant General Khumalo, were not to have any contact, interfere with, and or intimidate state witnesses, one of which was Adams. It is seen on television that there is a group of persons that have gone ahead to arrest Mr. Adams. That arrest has nothing to do with us. It is the police must carry on and do their work. There were reports that it is PKTT members who went to effect the arrest. It is now at this stage not a secret that the coordinator of the PKTT is Lieutenant General Khumalo. And the purpose behind it from the prosecutor was to determine whether someone else within the PKTT approved those trips. That is fine. And that if it was in fact General Khumalo who authorized those trips, then he was sending people to deal with Adams, and it could have a potential of interfering with the bail condition. It was asked on that basis. What subsequently happened is Mr. Adams appeared in court. The charges are read, and Mr. Adams has a way of how he expresses himself in public, and the prosecutors decided, the approval notwithstanding, can we just stand back and let them continue with their work?
Advocate Johnson, I want to say if that's the explanation he gave you, is a false explanation. Those individual members and anyone else in the world was under no bail condition that they could not, that's one reason, that they could not deal with any witnesses. There was nothing like that. If indeed the issue was to determine whether General Khumalo breached a bail condition, it was simply, and I'm sure Advocate Manilal knows that, you know that, it was simply a matter of asking General Khumalo, did you authorize an arrest of Mr. Adams? It's as simple as that. So if he gave you that explanation, it's false. He's not telling you the truth about why those questions, because that doesn't answer who went there, what are the names, give us the flight details. It doesn't answer the question whether there was a breach by General Khumalo of his bail condition. So no, I'm sorry, if you believe him, then something is wrong in this scheme of things. You should have, as soon as he said it, you should have seen it on his face, but that cannot be, it doesn't make sense. That you would go that way to try and determine that General Khumalo, whether or not General Khumalo has breached his bail condition. It's a false explanation.
So, Commissioner Baloyi, I hear you. I'm conveying the reason that was given. But Commissioners would, and Chair, you would remember my answer yesterday. I did say that if, in the manner that this process was used and what was requested by asking about PKTT, then it is an abuse of the process. I did stand by that, and I did indicate that there would have been a better way for us to have engaged and to find out what had gone on. I'm not deferring from my point. I don't retract my point. I just wanted to merely give clarity on, because I had to ask. I didn't know.
My hope is you saw through that explanation, and that's what I would have hoped you would say, that this is what he says, but I have a problem with his explanation.
That is why I stand by the proposal I made yesterday. I can't deviate from that proposal.
Yes, thank you.
And the problem is, in all that we have dealt with, particularly that arrest of Mr. Adams, it doesn't seem like anyone bothered to establish why he was being arrested. Had he committed, is he a suspect in a particular crime? How it comes across is because he was a complainant in some matter against inter alia General Khumalo, who happens to be the head of PKTT, a beggar subunit, that therefore Mr. Adams is somehow insulated from action by the PKTT, even where the PKTT has evidence of wrongdoing. That's the effect of it. So you brandishing that condition over General Khumalo to say, whatever wrong he commits, you dare not touch him because he's my witness, and if you do, you'll be breaching a bail condition. That's quite a bridge.
Of course, it doesn't make sense, because what I did do in that engagement, I asked,
please continue.
I asked this morning, if in fact, heaven forbid, but if in fact Mr. Adams committed what one would consider a political killing, what would we have asked? Why would we have asked? Because they would still have had to do their work. So it all comes down to the same thing. If they had a job to do, they should have been allowed to do the job.
Yes. Now, this is important, again, once again, going to the narrative, because what appears, at least at first blush to me, is IDEC seemed to have this gunshot approach to everything. That gunshot approach has got serious unintended consequences.
Perhaps more appropriately, shotgun, not just any gun.
A shotgun approach. It's got serious consequences. Let's go to General Mato's referral, which we have agreed is wholly non-compliant with Section 27. which, based on our conversation over the past 2 days, did not trigger the mandate of IDEC. But we are where SAPS seem to have concluded an unlawful contract with Mr. Matlala. But the prosecution for that sits on a highly questionable legal basis. Do you see the consequences? Because if the investigation is unlawful, the question must arise, what effect does that have on the prosecution, ongoing prosecution? Instead, had IDEC opted, in light of General Matlala's affidavit, General Matlo, the Sotho names. Oh, I do apologize. I apologize to both General Matlo and Mr. Matlala.
No, I think the second name is Matala.
I was going to say that, Commissioner Baloyi, I saw
Oh, yes.
the words, I saw the words charity, Matlala Matlo.
Thank you. Thank you.
Not
She intended to say Matlo, Commissioner Baloyi. Just thank you, General Kumalo. I must have fallen on that. My apologies for that.
Now you've called him General Kumalo.
Okay, it's time for tea, a break. Commissioner, I'll leave it there. The point I seek to make with you, Advocate Johnson, is that this affidavit ought to have at least triggered a conversation between yourself as head of IDEC and General Masemola, who at this juncture is not even a suspect in any wrongdoing, to alert him to the fact that there is a contract in your environment that there is reason to believe is tainted with illegality, and I expect you to take steps. The point I made that a faulty Section 27 may affect subsequent prosecution. You remember the fruit of a poison tree notion we discussed. And that's your challenge as IDEC. But if SAPS had run with the matter, they would never have this challenge. So because of the approach that IDEC has adopted, that running roughshod over everything, there is a serious risk, and I put it no higher than that it may have placed in jeopardy the very prosecution that is currently being pursued. Do you have a comment?
My comment, and again, you'll tell me, but it's not here, so my comment is that that 27 was read, as I understood it this morning, with the preliminary report, which sets out a more factual basis that links the different people and perhaps sets out the offenses. It might be better if, so I see, sorry, Chair, I'm not being cheeky. I see from the time that my wish to finish by tea time might not happen. And so I'm tired. But so I'm thinking then that if we're going to have to take tea and we're going to now have to finish by lunch, that I would have to ask if we could just get them to send us this preliminary report, because I cannot agree to that contention. I'm giving you what I have, that there was a basis for it. This 27 is not even open for a debate about the discussion we want to have, but I am unable to reconcile that they had nothing. There was a preliminary report that went with the affidavit. For me to agree to a contention in the absence thereof is highly irresponsible, and one that I'm not prepared to do, to future that in all likelihood has a sound legal and factual basis. And that is where I wanted to take the point. And then I'll take my cue from the chair about what we're doing for the rest of the day.
I would support you.
Go ahead.
I would support your request. I think it's a fair request, right? You have accepted that, at least on the documents that we have, on the reading of the affidavit itself, it doesn't suggest that such a preliminary report was provided. Yes. But since you've been made to believe that it was, I think it's a fair point that you consider it. You receive it, you consider it, perhaps you give the commission a copy, and then we see whether or not it addresses the concern that I have raised. And seeing as chair, it's 11:10, this might be an appropriate time. And on the second point, if I may say, General